Hello, everyone. My name is Michele Goodwin. I'm a Chancellor's Professor of Law at the University of California, Irvine, where I direct the Center for Biotechnology and Global Health Policy. One of our chief initiatives is our Reproductive Justice Initiative, which is sponsoring this hearing today on reproductive justice, Locked Out and Silenced, a call to reclaim women's reproductive and health care rights. This afternoon on this panel, we have it chaired by Judge Pamela Alexander. Joining her is Dr. Patricia Jones-Blessman and also Professor Aziza Ahmad. To my left are our witnesses providing testimony for a panel entitled Poverty and Politics, Undue Burdens on Girls and Women's Healthcare Access. I should also share with those of you in the gallery and our witnesses that the U.S. Supreme Court has granted cert in 7 petitions, including the Little Sisters of the Poor, that address issues of contraception and abortion. Today's hearing is incredibly timely. Without further ado, I'll turn it over to you, Chairwoman Alexander.
Thank you. Good afternoon, panel members. As you start, I would like you to introduce yourselves by stating your name, your organization, and then start your testimony. And Ms. Hooton, we will start with you.
So hello, everyone, and thank you to Professor Goodwin for putting this together. I was not able to make the first part of this morning, but I've heard from people in the bathroom and in the hallways that it was excellent. So my name is Angela Hooton, and I'm the Vice President of the U.S. Policy and Advocacy Program of the Center for Reproductive Rights, which is a global human rights organization that works to ensure that access to reproductive health care and ability to make reproductive decisions are guaranteed in law as fundamental human rights that all governments are legally obligated to protect, respect, and fulfill. For more than 20 years, the Center has been on the front lines of the legal battles over reproductive rights in the United States. And as we've already heard today, I think from one of my, my old bosses, Priscilla Smith, one of the most basic protections of the Constitution, the right to decide whether and when to have a child, is actually under assault throughout the nation. There have been more than 300 laws passed alone in the last 5 years that are designed to make it harder or impossible for women to access abortion services in their communities. And where not blocked by court orders, this new wave of restrictions, they're shutting down clinics, they're closing off essential healthcare services, and they are harming women. It is no exaggeration to say that today, a woman's ability to decide when and whether to have an abortion depends on whether she has the means and whether or not she lives in a state that is right now restricting it. Though the assault on women's access to abortion care is widespread across the country, it will undoubtedly have the most impact on women of color, those who are low income, and families in medically underserved communities. In cutting off access to care, these restrictive policies force women seeking abortion care to travel farther, to take additional time off of work, and to find extra child care. And they delay care for reasons that are not medically necessary, but are rather politically motivated. For women living in poverty, for immigrant women, for those who already struggle to access any reproductive health care services in their communities, and countless others, all of whom face their own unique circumstances, these unnecessary barriers to abortion care can be insurmountable. Moreover, many women already struggle to find ways to pay for their abortion care, since the federal government has severely restricted abortion coverage for nearly 40 years under the Hyde Amendment. These laws also contribute to what we all see and know as a culture of stigma and shame that surround those who provide abortions and those who seek their care. And as Professor Gilman already said, and as we sit here and speak today, the Supreme Court was conferencing this morning Whole Women's Health v. Cole, a challenge to 2 Texas abortion restrictions, as well as Currier v. Jackson Women's Health Organization, a challenge to a Mississippi law. Each regulation involved in these suits threatens to dramatically decrease access to abortion services in those states. The Center has brought both of these cases on behalf of the incredible abortion providers and the women they serve. So quickly, the Texas challenge involves two provisions of Texas House Bill 2, which many people know about because of the filibuster of Wendy Davis and the incredible advocacy work that many people in the state of Texas did. And despite their efforts, the Omnibus abortion statute was passed in the summer of 2013. So one provision involved in this omnibus statute requires any physician providing an abortion to have an active admitting privileges at a hospital within 30 miles of where the abortion is performed or induced. The second provision requires licensed abortion facilities to meet criteria for licensed ambulatory surgical centers, or ASCs. The challenged Mississippi law requires that all physicians associated with an abortion facility have admitting privileges at a local hospital. So the states of Texas and Mississippi falsely claim that these restrictions are about protecting women's health, which could not be further from the truth. Abortions are incredibly safe. In fact, less than 0.25% of abortions in the United States result in a major complication. It is clear that these are sham laws designed to sneak around the Constitution and drastically reduce abortion access. We won in the Mississippi case so far, which is not fully litigated yet on the merits, and our hope is that the court does not mess with that ruling. But we do hope and we believe that the court is going to grant cert in the challenge to the Texas law, because it has reached the court after a full trial on the merits, and if the court doesn't act, the Fifth Circuit ruling will stand. And that means that the state of Texas will be allowed to shutter more than 75% of the abortions, the state's abortion clinics, based on a law that serves no valid state interest. Before HB2 was enacted, and I think Scylla also touched on this, there were more than 40 facilities providing abortions in Texas that were dispersed throughout the state. As of today, that number has dwindled to 19, and unless the Supreme Court strikes down these requirements, that number will fall to 10. One of those 10, the McAllen Clinic, which is a city in Texas, would be limited to treating only women residing in 4 counties in the lower Rio Grande Valley, a very kind of specific piece of the ruling by the court, Fifth Circuit. It would have to turn away any woman that shows up at their doors in neighboring counties, even though the next closest abortion provider is San Antonio, which is more than 200 miles away. So just imagine, you have your clinic, it's open, and a woman comes, and you look at her ID, she finds out, and you send her away 200 miles away because you are not allowed to serve her because of a court order. Just for context, you should know that Texas is the second most populous state in the nation. It is home to 5.4 million women of reproductive age. More than 60,000 of those women every year choose to have an abortion. Texas is also the second largest state in the country in terms of geographic size. And as a comparison, New York State, which has 4 million women of reproductive age, has 250 abortion providers. And California, which has 7.8 million women of reproductive age, has over 500 abortion clinics. Texas is going to be down to 10. But again, this is not just about an abstract fight over facts and figures or constitutional law. Real women are impacted by this. In Texas, the impact is especially devastating to women, predominantly Latinas, who live in the Rio Grande Valley. The valley is an impoverished area along the border, the southern border with Mexico, where over 1.3 million residents reside. And as I said, the only abortion provider remaining in the valley now is the clinic in McAllen. If this last clinic has to close, Latinas in this area will have to travel very, very far, hundreds of miles, also past immigration checkpoints that they've set up along the southern part of Texas in order to find a clinic. Many will decide they can't make this trip. Many others will take matters into their own hands. And we already have documented stories and research looking into that. It is happening, and it's on the rise. And this is on top of the cuts to family planning and other important reproductive health care services that Texas has instituted over the last few years and continued this last session. As a result, the health care safety net for women has been severely damaged. I've been to the Valley. I was there recently, and I met with many of the activists from the Latina Institute who call themselves poderosas, rightly, and they're standing strong against all these odds, and their stories of hardship, of resiliency will move anyone. But what's most stunning to me is that the state of Texas could just be so cruel to the families and the women who are really the backbone of that state, in terms of economic and basically the entire infrastructure in Texas economy relies on these families. Some of the women described to me and to others at the events and meetings having nowhere to go after discovering a lump in their breast, a tumor in their ovaries, no way to access contraception, and the human rights violations in the Valley are staggering. We could have a whole separate meeting about that. And as a Latina with family roots, deep family roots in Texas, I take this personally. You know, as a mom, I take this personally. I believe firmly that nobody should be denied critical health care, and nobody should be denied the ability to determine when and whether to have a child, which is one of the most transformative decisions we can make in our life. It certainly was the most transformative decision I've made in my life. So I think to deny women that control is to deny them their dignity and their ability to control and chart their own destinies. So to close, today we find ourselves at a critical juncture. Goes without saying, we've got to fight all this stuff. We have to fight these injustices, as many as there are right now, and it's sometimes, honestly, day to day, it feels overwhelming. There are cases, as we've all talked about, pending before the Supreme Court that will define the right to safe and legal abortion for the next generation. And we are confident that the U.S. Supreme Court will do the right thing. It's done it before. It should do it again. But even if we are successful in securing that right, we know that it's, for many women, it's a right on paper. And we have to go much beyond what the Supreme Court says and does next June. So a couple other strategies. There's very important bills pending in Congress right now. The Women's Health Protection Act, which would prohibit states, create a federal statutory protection against what the states are doing, and prohibit them from imposing these types of restrictions. And also, Congress needs to act in support of the Each Woman Act, which would lift the bans, the discriminatory bans on abortion that have been in place for too long. And state legislators need to start prioritizing. I mean, this is not what their constituents want them to do. Some of these states have 15 restrictions on abortion on the books. They look for every year, instead of working on jobs and minimum wage and the economy and education and all the things that people actually expect and want their state legislators to do. And finally, a plea to people in this room and people who may hear this recording later. We need people to speak out. We need people to tell their abortion stories. We need people to talk to their lawmakers, speak up. This next year is, and I'm sure people have heard this before, it really is true. This is one of the most pivotal years for so many rights. And if people don't start hearing that this is real for many of us, we're not going to be able to change the culture, and we're not going to be able to change the law. So thank you so much for your time.
Thank you. Ms. McDonald.
Hi, good afternoon. My name is Carol McDonald, and I'm the Director of Strategic Partnerships at Planned Parenthood Federation of America. Planned Parenthood is the nation's leading sexual and reproductive health care provider. We serve 2.7 million patients in our health centers each year, an additional 1 million through our education programs. I work in our national headquarters on health policy, politics, and advocacy, and I'm here to talk to you today about the current state of healthcare access for women and girls and the direction of the political debate around these issues. I want to particularly touch on the impact of the Affordable Care Act on healthcare access for women and girls, as well as highlight the ongoing attacks that Angela already talked about on reproductive health care at the state and national level. So starting with the Affordable Care Act, to me that's a real grounding place because so many women have been impacted by it so far, and yet there's so much more that can be done through that policy vehicle. Almost 13 million women of reproductive age are currently eligible for health care insurance that previously have not been insured before. And of that 13 million, 5.5 currently have access to woman exams, birth control, breast and cervical cancer screenings, and mammograms, all without copays or other out-of-pocket expenses. The uninsured rate for Black women since the implementation of the Affordable Care Act has dropped by 10%. That is significant, and that is the beauty of the Affordable Care Act, the breadth of the impact that it can have. And at Planned Parenthood, we know firsthand the tremendous positive impact that the ACA has had on women and girls and families in particular. I could spend the remainder of my time bragging of the work that we've done to enroll people in the ACA, but I just want to highlight a few key facts. Nationally, we had conversations with 2.5 million people about enrolling in the Affordable Care Act. We actually assisted almost 230,000 individuals in starting the enrollment process. We offer all of our materials in English and in Spanish, including a Spanish language website. And we have trained bilingual assisters for in-person enrollment support in every state that we work in. In addition, we had over 3,000 enrollment events across the country. One of the major provisions of the ACA that's designed to reduce disparities in access to health care was the expansion of Medicaid eligibility to nearly all low-income individuals. And this primarily impacts women, those with incomes at or below 138% of the federal poverty level. And again, this was intended to be implemented nationally, but we know that in June of 2012, the United States Supreme Court ruled that Medicaid expansion is optional for states. So in those states that chose to expand Medicaid, 11.2 million women, men, and families have gained access to low-cost or free coverage, either through Medicaid or through CHIP, the Children's Health Insurance Program. And there is a over 10% decrease in the unmet need for medical care due to cost. However, as of today, there are 20 states, primarily in the southern part of the United States, that are not planning to expand Medicaid at this time. This means that the median income limit for those in those states will be 44% of the federal poverty line, which equates to an annual income of $8,400 per year for a family of 3. Further, in nearly all of these 20 states, childless adults remain ineligible for coverage. On the other side, you also have many adults who make too much money in these states to qualify for Medicaid, and too little to qualify for any of the marketplace tax credits that are afforded under the ACA. That's an estimated 3 million adults, 90% of whom live in the South, that fall into this coverage gap. The coverage gap disproportionately is comprised, not surprisingly, of people of color. Among uninsured adults in the South who would be eligible for Medicaid expansion, 54%, over half, are people of color, and 56% of African Americans would fall into this coverage gap. So what is the impact of this for women and girls in particular? In the states in question, 7 out of the 10 states with the highest teen pregnancy rates are in the South. The South is home to more people living with HIV and dying of AIDS-related complications than anywhere else in the country. And in the South, though women are not more likely to get breast cancer, they are in fact more likely to die from breast cancer. These disparities are stark, they're undeniable, and they are unacceptable. The average life expectancy of people living in New Orleans can vary by up to 25 years across neighborhoods, just a few miles apart. In addition to states refusing to expand Medicaid, state and federal legislators have continued to attack women's health, and again, Angela alluded to much of that, including access to contraception and safe legal abortion. Today, 6 out of every 10 women live in a state that is hostile to abortion rights. Earlier this year, the House of Representatives voted on a bill that would ban abortion at 20 weeks with limited exceptions and burdensome reporting requirements. Republican presidential candidates have also consistently opposed women's health care and have promised to, if elected, defund Planned Parenthood, re-educate women about abortion, and overturn Roe versus Wade. They've called oral contraceptives abortion-inducing drugs, and they've supported the House's 20-week ban. States are introducing bills that would require abortion providers to have admitting privileges at nearby hospitals, hospitals which were often religiously affiliated and will not grant such privileges due to faith-based objections. They've passed bills to ban the use of medication abortion, require waiting periods for women to have an abortion, which again primarily impacts low-income women, or require that an abortion facility meet the same standards as a hospital, including mandating things like the number of water fountains required in the facility or the width of hallways. The same states attacking abortion access are also restricting access to birth control and cutting family planning. The Center for Disease Control and Prevention named family planning one of the 10 greatest public health achievements of the 20th century. Yet despite this, coordinated attacks on women's ability to access this care continues. In fact, the attacks on contraception and family planning have increased over the last few years and often come under the guise of religious refusal or religious freedom restoration laws. These laws empower doctors or pharmacists with personal objections, not medical or professional standards, to refuse to provide emergency health services, dispense birth control, or emergency contraception. For rural women, women in small towns, or those lacking affordable and reliable transportation, encountering a pharmacist who refuses to fill a prescription can mean that there is nowhere else to turn. State legislators have debated cutting breast and cervical cancer screenings at Planned Parenthood simply because they disapprove of the full range of services that we provide. The state of Texas, again, forced more than 70 women's health centers to close by cutting funding for family planning by 2/3. by barring Planned Parenthood from participating in the Texas Women's Health Program and closing almost 12 centers that provide safe legal abortion. The remaining Texas clinics were unable to accommodate the patients who lost access to their preferred women's health provider. Legislatures in other states have tried to bar Planned Parenthood patients from accessing care through Medicaid. In Louisiana, a judge has blocked a preliminary decision, has issued a preliminary decision blocking Governor Jindal's attempt to do this, and there have been similar rulings in Arkansas and Alabama. In a recent piece in the New York Times, local and national public health officials made it clear that other providers cannot deal with all of the patient's needs if Medicaid patients can no longer go to Planned Parenthood for care. Access to family planning and effective contraception is also impacted by structural and historical issues. For example, LARCs, or long-acting reversible contraceptives, are the most effective method of birth control since they can provide coverage for over a decade. But sometimes the upfront costs are a barrier, and furthermore, certain communities have a distrust of the medical system due to America's history of trying to control Black women's fertility and reproduction, including forced sterilization, the targeting of long-acting contraceptives for use in low-income women, and only incentivizing the insertion of these methods, but not their removal. Recognizing how the burden of these restrictions and the toxic political environment falls on women, especially women of color, where does that leave us, those who are patients, those who are providers, policymakers, and advocates? 3 things. 1, we must push states that have not done so to expand Medicaid. This single action will have the most significant impact on healthcare access for those in need. 2, we have to push back against the attacks on abortion and family planning that were mentioned previously, and make those who advocate for these restrictions pay a political price. And 3, we must fight these battles for access for healthcare that impact those most marginalized by centering them, their stories, and their lived experience at the centers of our campaigns and our advocacy. Thank you.
Thank you. Ms. Gilman.
Good afternoon. My name is Michele Gilman. I'm the Venable Professor of Law at the University of Baltimore School of Law, where I'm a co-director of the Center on Applied Feminism. I'm also the director of the Civil Advocacy Clinic, where I've spent almost 20 years representing low-income people in civil legal matters. As we've heard throughout this day, legal restrictions on reproductive rights disproportionately impact low-income and minority women. These are the women most locked out and most silenced. Through my clients, I have seen firsthand how these barriers not only limit women's autonomy and life choices, but also reinforce patterns of poverty and economic inequality. There is a sharp class divide in reproductive health access, ranging from who gets comprehensive sex education, to contraception, to abortion, to prenatal care, to postnatal care, to workplace supports for pregnant women and new mothers. Low-income women are not being disadvantaged solely on the basis of gender, but rather due to the intersection of race, gender, and class. 70% of our nation's poor are women and children. We have new census figures out last month on poverty in the United States. 1 in 7 women live in poverty, or 18 million women. The poverty rate for women is 14.7%. These numbers are much higher for women of color. But that's not the whole story. The poverty line right now, for example, for a family of 4, is for a family earning less than $24,008. Okay? That means if you are a family of 4 earning $24,009, congratulations, you're not poor, right? We know that's absolutely ridiculous. So it's much more accurate to say that 1 in 3 women, or 42 million women, and 28 million children live either in or on the brink of poverty. This class differential that I'm talking about is not solely the result of a religious right agenda that hits certain regions hardest. Rather, there are three faulty assumptions about poor people that underlie the disregard for the reproductive rights of low-income women. Fallacy number one, poor women are not deserving of assistance. Many reproductive health policies, as we've talked about today, are built on a distrust of poor women. For instance, many states deny welfare benefits to families over a certain size or to women who have additional children while on assistance. These laws are built on a myth that welfare families are larger than other families and that the sexuality of welfare mothers needs to be controlled. In fact, the average number of children in a welfare family is 1.8, which is lower than the national average. Moreover, studies establish that poor women do not conceive children in order to obtain meager welfare benefits, which average nationally $380 a month. Other welfare policies reflect similar suspicion of poor women, such as mandatory home visits and drug testing. Widespread myths about so-called welfare queens perpetuate public disdain for all low-income women, and they lower public support for a wide range of important safety net and reproductive health programs. Rather than supporting low-income pregnant women and new mothers with comprehensive health care, many states are instead punishing pregnancy. Under both federal and state laws and court decisions, pregnant and new mothers who test positive for drug use, and these tests are usually performed without consent, might not only be accused of child abuse and neglect, but may also face criminal charges, as we heard earlier today. The loss of their children and personal liberty can result, despite research showing that not all maternal drug use is harmful to infants, and that many families could remain intact with addiction treatment for mothers. The unfounded myth of the crack baby marks low-income women as deviant and leads to additional social control policies that are harmful and stigmatizing. Fallacy number two, the government is not responsible for poverty. While all women have a constitutional right to abortion as established in Roe v. Wade, this right can be illusory for poor women who cannot afford an abortion. We've talked about the Hyde Amendment. It was enacted in 1976. To this day, it prohibits federal Medicaid funds from being used for abortions, even those that are medically necessary. And despite its otherwise positive advances for women's health, the Affordable Care Act, which we just learned a lot more about, extends the Hyde Amendment's funding ban through its expansion of Medicaid coverage and permits states to impose it on their private health insurance exchanges. The Supreme Court ruled in a case called Harris versus Mcrae in 1980 that the Hyde Amendment is constitutional, reasoning that indigency, rather than the government's funding denial, restricts the ability of poor women to access abortion. This is a false dichotomy between private and public action, given the government's extensive role in creating and perpetuating poverty, ranging from its creation of segregated neighborhoods, to its mass incarceration policies, to underfunded and inadequate schools. The court's assertion in Harris versus Mcrae is particularly ironic, given that its own decisions that limit access to abortion contribute directly to women's poverty. Fallacy number three, living in poverty is a minor inconvenience. As we've heard, states are increasingly imposing a variety of restrictions on abortion, such as waiting periods and elaborate clinic facility regulations and the like, all of which purposefully make abortions more time-consuming and expensive. Numerous clinics have been shuttered as a result. Nevertheless, several courts, like the Fifth Circuit, have determined that these restrictions do not create an undue burden on women and are therefore constitutional. As we've heard, in considering onerous abortion restrictions in Texas, a federal appeals court stated that travel distances of more than 150 miles one way are not an undue burden. This shows a complete lack of understanding regarding the difficulties that poverty imposes. Traveling long distances adds additional costs to an already expensive medical procedure. These costs include transportation, a hotel room, because remember their waiting periods, childcare for the children that a woman has to leave at home, and lost wages, and sometimes a lost job because we do not have Many low-income working women do not get paid leave. Not surprisingly, studies have established that women seeking an abortion often skimp on food, utilities, or rent. From their position of privilege, many judges fail or refuse to acknowledge the enormity of financial barriers that abortion restrictions pose to poor women. So what are my recommendations? Legal barriers to reproductive justice should be removed. While reproductive rights rhetoric is often framed in terms of choice, it's important to realize that poor women rarely have options. Poverty restricts reproductive justice. If you're poor, you lack the resources to access a wide range of reproductive health services and supports. In turn, a lack of reproductive justice further entrenches poverty. If you cannot control the size of your family, the timing of your pregnancies, you will struggle to complete your education. You will struggle to remain employed. You will struggle to advance in the workplace. Thus, economic stability and reproductive justice are mutually reinforcing. For all these reasons, we must recognize, confront, and rebut the faulty assumptions about the poor that underlie this nation's restrictive reproductive health policies. Thank you.
Thank you, Professor Gilman. Ms. Goler.
Good afternoon. Poverty is not a character flaw. My name is Linda Goler Blount, President and CEO of the Black Women's Health Imperative. And since 1983, the Imperative has been the only nonprofit organization committed to advancing the health and wellness of the nation's 21 million Black women and girls. And we do this through advocacy, public policy, research translation, health education, and leadership development. Thank you for this opportunity to speak at this very important hearing. For 32 years, we have championed reproductive health for all women, as well as informed choice for legal and safe abortion. The Imperative's national campaigns, publications, and digital media serve as models for exploring our sexual health and the female body in a positive and open manner with Black women and girls. We understand the interdependence of social determinants of health and that reproductive justice is actually justice in health. And justice in health is also justice in education, housing, transportation, food, among many other factors. There are those who view poverty as if it were a choice, as if poverty could only be the result of a series of bad decisions. Poverty is many things. It's linked to hypertension and diabetes. As Sam Broder, the former head of the National Cancer Institute, said, poverty is a carcinogen. For far too many, poverty results from a single event, a job loss, a serious illness, or the birth of an unexpected child. Poverty is many things. It is not a character flaw, and neither is being a Black woman or a Latina. The 2008 report, Characteristics of U.S. Abortion Patients, found that 42% of women obtaining abortions live below the federal poverty line. For most poor people, social mobility is a myth. Researchers at Harvard and Berkeley found in Atlanta, for example, that a child born into poverty has only a 4% chance of getting out of poverty, ever. So let's remember this. Recently, there was an article in the Wall Street Journal. In it, Jason Riley, the writer, fueled his opinion with high-octane self-hate and misapplied facts, stating that poverty is not the real reason Black women have abortions. He would have the reader believe that Black women whose abortion rates are 4 times higher than white women simply have no faith in Black men as an explanation for the current rates of abortion. The facts are, women of color are more likely to live in poverty and more likely to suffer the consequences of an unintended pregnancy. Women who cannot afford to pay for abortion services out of pocket are forced to wait for clinic appointments on average 3 to 5 weeks longer into their pregnancies when abortions are riskier. Here are a few facts that Mr. Riley didn't consider. The abortion rate among American women is as low as it has been since Roe v. Wade. That means many women who seek abortion care have been able to find services. However, 1 in 4 Medicaid-eligible women who seek an abortion must carry her child to term because there are no state funds available, making it next to impossible for her to change her socioeconomic status. Black women have significantly higher unintended pregnancy rates than any other demographic because of historic mistrust of the medical community and lack of access to contraception care and information about reproductive health. That can't be separated from poverty. Latinas with incomes below the poverty line have higher rates of abortions than Black or white women, due in part to very valid concerns about their immigration status and the possibility of being separated from their children or having their entire families deported. No woman wakes up and says, you know what, I'll have an abortion today. This is a deeply personal and emotionally challenging decision and wrenching. Of course, every able woman has a responsibility to do her best to avoid an unplanned pregnancy, and believe me, the vast majority try. But if she doesn't have access to information or quality reproductive care services, then she can't make the best choices for her health and well-being. If she doesn't have health insurance, then she likely can't afford contraception care. And if a woman is poor and lives in a state without Medicaid expansion, she may not be able to afford to buy health insurance from the exchange. This apparently leaves her with one choice: abstinence. That seems like quite the penalty to pay for being poor. Half of all pregnancies are unplanned, and 21% in this country end in abortion. And we know the main reason women terminate their pregnancies is because they simply can't afford to have a child. And that's understandable. In 2014, the Department of Agriculture reported that the average cost of raising a child by a couple whose income is between $61,000 and $106,000 a year was $245,000. For couples earning less than $61,000 a year, that cost was $176,000. When a low-income mother can plan her pregnancies, she's much more likely to adequately provide for her family. 25 years ago, Black feminists and other progressive thinkers realized this and understood that systemic racial discrimination, sexism, and reproductive health were interdependent. Kimberly Crenshaw defined this as intersectionality. These issues and others were deemed justice issues because they represented structural, social, political, and economic barriers to health and well-being. At a 1994 Black Women's Caucus of the Illinois Pro-Choice Alliance Conference, the term reproductive justice was coined. Reproductive justice, as we look at it, is the right to have children, the right not to have children, and the right to raise your children in a safe and healthy environment. Today, we experience relentless attacks on reproductive justice. Targeted regulation of abortion providers or trap laws are far becoming the biggest barrier to women exercising their constitutional right to make decisions regarding their bodies. State trap laws are in place in over half the U.S. and require, as we've heard, prolonged waiting periods, invasive counseling, and forced ultrasounds, creating the ultimate inconvenience for poor women. Few in this room can imagine having to borrow money, jeopardize her employment, or arrange childcare or travel long distances, only to be told to come back in 2 days. Anti-choice lawmakers have introduced over 300 new restrictions on abortions in the past 5 years. So who will advocate for poor women? Of 535 members of Congress, 23 are Black women and Latinas. Of 7,382 members of state legislatures, only 322 are Black women and Latinas. We need lawmakers, male and female, Democrat and Republican, who can advocate for women's health. Representative Henry Hyde said, "I would certainly like to prevent, if I could, legally anybody having an abortion, a rich woman, a middle-class woman, or a poor woman. Unfortunately, the only vehicle available is the Medicaid bill." When the Hyde Amendment passed 39 years ago, almost instantly, significant barriers to health for women were created, particularly low-income women and women of color. This law, as we've heard, bans the use of federal funds for abortion services for women who need them most, and these are women most likely to face barriers to these services. This is why the Black Women's Health Imperative supports the Each Woman Act, a bill that will ensure that every woman who receives health care insurance through the federal government will be covered for all pregnancy-related care, including abortion. Its passage would lift the restrictions to access to abortion for millions of women of reproductive age who are enrolled in Medicaid, and the act will prevent federal and state and local legislatures from imposing their anti-choice, anti-constitutional opinions on private insurers that offer abortion care. Ladies and gentlemen, the Hyde Amendment must be repealed. The reproductive justice movement is about the self-determination of women and their rights to decide what is best for their bodies and families when it comes to childbearing, and to not be penalized due to their socioeconomic status, race, or ethnicity. For these reasons, we call on anyone interested in the health and well-being of women to support the Family Medical Leave Act, equal pay for women, and paid child care. To do otherwise is to condemn generations of bright, talented, hardworking women and their children to a lifetime of poverty. The Black Women's Health Imperative began as a self-care organization because our founder, Billie Avery, and her sister feminists realized no one was going to take care of us, that we are the ones we are waiting for. We've been caring for ourselves and fighting the war that policymakers have waged on Black women and women of color, their wombs and their health care ever since. It's time for the war to end. Thank you.
Thank you. Ms. Hollinger.
Good afternoon. My name is Krista Hollinger, and I work for the University of California, Irvine, located in Orange County, California. I'm the Chief Administrative Officer for the Department of Obstetrics and Gynecology there. I'm honored to be here today to speak to you and just to be participating and hearing all of the testimony that we've heard today, which has all been so enlightening and also brilliant. So thank you to everyone. I'm here to represent the physicians with whom I have the privilege every day of working, who have committed their careers to providing compassionate reproductive health care of the highest quality to women in our community and to training the next generation of obstetricians and gynecologists. Today, I would like to tell you about the important work our doctors are doing each day to improve the lives of women and their families, despite the obstacles many of these women face to access our services. The decision of whether and when to become a parent is one of the most personal choices a person can make. And the dream of being a parent starts for many from a very young age. Little girls, myself included many years ago, dream about being a mother as they play with their dolls. For many couples, parenthood is talked about during courtship as they share their dreams with each other about getting married and raising children and explore whether their own individual notions are compatible with their partners. Some couples choose not to become parents. And many women and men make decisions about their education and career based on their goals for family life. Accordingly, the Supreme Court has repeatedly upheld that the decision whether or when to become a parent is a most basic personal decision that is protected under our constitutional right to privacy. The highest court's rulings on this subject have a long history, as we know. In the past half century, this right has been guaranteed in landmark cases Griswold v. Connecticut, Eisenstadt v. Beard, Roe v. Wade, and Planned Parenthood v. Casey. As the Supreme Court has said, if the right to privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision of whether to bear or beget a child. Women have a legal right to obtain family planning services, including contraception, testing for sexually transmitted diseases, and abortion. But unfortunately, that legal right is not enough. The legal right to contraception means nothing to women like our patient Monique, who lives in an area where her only option for hospital care is a religious hospital that restricts the type of reproductive health services available to patients. Monique is a 40-year-old mother of 4 who has finished growing her family. She desired a tubal ligation during her delivery of her 4th child, which is best medical practice, and had completed the paperwork with her state-funded insurance plan for the permanent contraceptive method. Monique delivered at a religious hospital, which denied her request for a tubal ligation. Monique was not told by her state-funded insurance plan that the hospital with which it contracted would not provide the service. We are now treating Monique for her 5th pregnancy, which has a high risk of complication. We know that providing family planning services saves money. It is estimated that for every public dollar spent on family planning services, more than $7 is saved. This adds up to more than a $13.5 billion savings annually across the United States. It is estimated that the number of unintended pregnancies, unplanned births, and abortion in the United States would have been 60% higher in 2013 without publicly funded family planning services. Medicaid, Title X, and now the Affordable Care Act provide a couple $2 billion in funding for family planning. We have a lot to be proud of in our efforts to expand access to low-income women. But there's still a great deal of work to do, as we've been talking about today, and a lot to be concerned about for those of us who are committed to ensuring that low-income women in this country have an equal right to obtain care. Poverty remains one of the largest barriers to accessing family planning in this country. In 2013, 8 million women received publicly supported contraception services, but this is less than half of the women who needed it. For women who live in one of the 10 states that prohibits entities who provide abortion from even receiving family planning funds for non-abortion services, access to affordable contraception and health screenings is severely limited. The legal right to an abortion means nothing to women in our country who do not have an insurance plan that covers abortion and do not have the financial means to pay for one. Poor women have very few resources available to them due to the Hyde Amendment, restrictions of 33 state Medicaid programs on abortion funding, laws in 24 states essentially banning abortion coverage in plans that are offered through the Affordable Care Act's health insurance marketplace, and bans in 10 states on insurance coverage of abortion in all private insurance plans regulated by those states. We met a woman in one of our clinics this past week who lives in one of these states and did not have the means for paying for an abortion. Tanya is now in her 3rd trimester of pregnancy. Her pregnancy is covered by public funding, but the abortion was not. And she is trying to figure out how she is going to afford diapers and childcare. She had made a difficult choice for herself, one she did not take lightly. However, it was based on the reality with which she herself is living. Unfortunately, Tanya was not able to carry out her choice simply because she is poor. Like Tanya, many women cannot afford the out-of-pocket cost for abortion. Our physicians see the consequences of this every week, such as poor women who are forced to carry a pregnancy to term because they cannot afford the abortion, or who have delayed coming to see us weeks because they were saving up enough funds to do so. For women with high-risk conditions, this delay adds to more risk of health complications. And here's a reality that continues to astound and frighten me. 89% of counties in our country do not have an abortion provider. For poor women who live in one of these counties and do not have the means to travel to another county, abortion access is not a right they enjoy. One of our patients, Mary, knows this difficulty firsthand. Mary was referred to us for a pregnancy termination from a semi-rural area just outside our county's border. Mary is a mother of 4 with a history of seizures, narcolepsy, and anemia, all of which made her pregnancy very high risk for high complications for herself and her unborn. Desperate to find a doctor who could care for her, Mary drove herself 2 hours to see us, even though she tries never to drive longer than 15 minutes at a time because she falls asleep while driving. When Mary was seen in our clinic and discovered that her procedure was scheduled for the following day, she almost canceled because she did not have childcare to stay overnight. This made an already difficult and stressful situation even more challenging for a woman who was making a personal decision that she knew was best for herself and for her 4 children. Mary was fortunately able to find someone to watch her children for the night and the next day, but if she lived in a state with a 72-hour waiting period, accessing the health care she needed would have been undoable for her. Mary is not alone in shouldering undue burdens when attempting to access reproductive health care that our Supreme Court has ruled is constitutionally guaranteed. Many women, particularly poor women, seeking abortion services are faced with a variety of barriers, such as restrictions on medication abortion, mandatory ultrasounds that women are forced to view, mandatory waiting periods of up to 72 hours between a consultation with a physician and the abortion. For women with childcare responsibilities, struggling to make ends meet and not able to miss any work, this waiting period makes the access of service an impossibility. It is especially so for those who have had to travel many miles, as our earlier described patient Mary. This, of course, is the point of the requirement. None of these requirements is based on a medical necessity, nor do they have any impact on how a physician who is medically trained to evaluate a patient makes a medical recommendation. The family planning physicians with whom I work are brilliant, compassionate, objective, and courageous. They have an undergraduate degree. They've gone through 4 years of medical school, 4 years of residency in obstetrics and gynecology, and 2 years of fellowship in family planning services. They are trained to provide safe health care and medically accurate information to women who come to them with many questions and many times a lot of heartache. The mandatory requirements for ultrasound, for example, place a barrier between a woman in need of services and the person who is the most trained and qualified to provide those services. We do not require stroke patients to view their MRI before we administer life-saving treatments. And the last time I checked, we do not require men undergoing prostate cancer treatment to have sexual health counseling first. And make no mistake, family planning services saves lives also. To question that a physician can safely provide family planning care to a woman, and to question that a woman is incapable of making that decision for herself and her family is an insult. As I began this testimony, I said that the decision on when and whether to have a child is a deeply personal one that is protected by our constitutional right to privacy. And like every constitutional right in this country, it is meant to be guaranteed equally to young and old, black and white, rich and poor. Every woman deserves and has the right to accessible, quality family planning care. This is good for women, good for families, good for the economy, and good for our society. Thank you.
Thank you, panelists, for your moving and passionate testimony on these very important issues. You've enlightened and educated us. Now we have a few questions for you. Ms. Hooton, the first question I would like to ask is, what do you envision the next steps being after the Supreme Court rulings on these two cases, either way they go?
It's a great question. We'll flash back to law school here. Let's be talking to the judge. So let me think. I would love to say that we have everything figured out. We're still figuring out exactly what the response is going to be. So we hope and expect that the court will do the right thing. And as everybody has reiterated, this is not a kind of an issue of first impression. They have ruled on what an undue burden should mean, and we feel strongly that the facts in the Texas case and the Mississippi one very clearly show that this is an undue burden. If what's happening in Texas is not an undue burden, then that standard has no meaning, in my opinion. That being said, you cannot predict, 100% what the court will do. They could do a more nuanced decision that would tweak some of the judicial standards and would leave us needing to figure out, from a communications and advocacy perspective, how do we continue to raise awareness about the importance of the right? How do we talk to people? Do we want to frame it as a full victory and kind of move on? Probably not, no matter what. We know that this issue is not going to go away. I wish that the Supreme Court's decisions would put an end to the legislation so that we could focus on the access issues. My prediction, given what the state legislators look like, is that they will continue to do and push the envelope, and we have to remain vigilant. So stay tuned as we kind of unpack a little bit more once we're deeper into the case, what we think and where we think the court's going to go, and collectively come up with a set of responses so that we can prepare, again, to continue this fight, but also hopefully use whatever decision comes out in a way to, at least for a while, stymie some of the craziness that has been coming out of the state legislatures in the last 5 years. But here's to hoping, right?
Thank you all so much for these wonderful presentations. I have a few questions for everybody. I'll just put them all on the table. For Ms. Hooton, I was curious if you could talk a little bit about, even though it's coming probably from a non-justifiable place, if you could talk about some of the arguments that are thrown out there, the evidence that's offered to justify on health grounds these types of trap laws. And also if you could talk a little bit more about the Women's Health Protection Act and what does the future of that act look like. Ms. McDonald, I was wondering if you could speak to the real-world barriers to enrolling poor women into the ACA? And also, you mentioned the history of distrust that exists, and this morning we were hearing about sort of contemporary issues of distrust, so women being incarcerated after, for example, their contact with hospitals, and I would love to hear your thoughts about how we should overcome some of these challenges. Professor Gilman, I was wondering if you could speak, as well as Ms. Goler Blount, to speak to, I'm sorry if I'm mispronouncing your name, if you guys could speak a little bit to what it really means for us to repeal the Hyde Amendment. Is this a possibility? This morning we were talking about repealing the Helms Amendment. It would be great to know if that's a thing that could happen. And for you, Ms. Goler Blount, I'm just wondering if you could talk a little bit more, the many myths that you told us about and spoke against in your talk seem like common sense, that these are myths, but they're so persistent. And I was wondering if you could talk about why they persist and what animates that kind of hostility and racism. And finally, Ms. Hollinger, I was wondering if you could speak to the role of physicians in advocacy. So what role should physicians play in the context of the upcoming proposals and legislation that will be proposed, hopefully. Thank you.
And you each have about 1 minute.
Okay, so quickly, I don't want to give too much credence to their arguments because I don't think that they actually even genuinely believe them. But what arguably they put out for the admitting privileges in ASCs is, for admitting privileges, the idea that if you have an emergency in a clinic and a doctor needs to be able to follow that patient and in the hospital that's nearby and make sure that they can, again, follow the patient and go see them if there is an emergency. So they creatively came up with this admitting privileges requirement. The reality is most abortion providers, when they, as Carol said, they're not getting the admitted privileges because of the pressure on the hospital and the potentially kind of Catholic directives. The other reason is that they have just basic guidelines that you have to have a patient at least one every, whatever month or few months, and abortion providers don't have that many patients that have emergencies, which is great. It's a very, very rare, and so they don't even qualify in a non-politicized way for that. So it's a very creative, but it's not about women's health. And also, if there is an emergency, a woman can always go to an emergency room, and the doctor can come. That is, there's basic laws around being able to get care in the nearest hospital. The second, ASCs. It's a little bit about, again, what we heard from other panelists about, having, I guess the idea of the more clinical it is, the safer it's going to be, and some of the things around janitor rooms, et cetera. They have laundry lists of why they think these are arguments of health, but we can debunk them. And in the trial record, which I encourage everybody to do, it's a fascinating read from the district court, we take them on each of those and debunk the fact that there is no basis in actual evidence to show that this would improve women's health. Really quickly on the second question, the Women's Health Protection Act, again, it's a pending bill in Congress, and what it would do is stop these bills from being introduced in the first place by creating kind of a federal statutory protection. Right now, there is no federal statutory protection for a right to abortion and to prevent the states from passing these laws. So it would prevent states from imposing restrictions on reproductive health care that do not apply to similar medical care, that interfere with patients' personal decision-making and block access to safe and legal abortion care, has a set of per se violations. It's a really great creative bill. It doesn't do everything. It needs to be complemented by the Each Woman Act and other efforts, but I encourage all of you to check it out and read and learn more about it.
So your first question about was about barriers to ACA enrollment. In large part, if you're dealing with a population that is not used to having insurance, there's a lot of education that needs to be done about what does it mean to have insurance? How do you then use that to access care? And what we have found is that the best way to overcome that barrier is having face-to-face conversations with people, and that is labor-intensive, that is expensive. But that is the best way to overcome that knowledge gap of what is it then that you do. In addition to that, even once you get people enrolled, you then also have to continue the discussion about then accessing care and letting people know that they have access to preventative care, that they don't have to wait until they're sick in order to go see a healthcare professional. So all of these are can be impediments to folks seeking full care, and therefore that education process needs to continue. In terms of contemporary mistrust of, I don't know if you mean healthcare in general or reproductive health particularly.
This morning we were hearing about, for example, women being tested for drug use during pregnancy and it leading to their incarceration. And so, you know, it just kind of flows with the stories you were talking about with sterilization and long-term contraception. And yeah,
so I think there's a little bit of, so there are a couple of things. I think that there's historic mistrust that I spoke to earlier in terms of how the state has interacted with healthcare for poor women. I think that for us also as a movement, you know, we continue to deal with the legacy of Margaret Sanger and the origins of the birth control movement that was rooted in eugenics, and that those perceptions still make people nervous today, and we hear about that at Planned Parenthood fairly regularly. I think in addition for women who come from who either come from immigrant communities or who come from mixed status households, there is a fear of what is going to be disclosed about their status and how that is going to be used against them. We are very clear at Planned Parenthood that we see everyone regardless of that status. But I think that in general in healthcare those have been the kinds of things that we've seen.
Okay, so you asked about the odds of repealing the Hyde Amendment, and I would say in the short term, the odds are low, but that doesn't mean that we shouldn't continue the fight in the long term. And what I'm seeing more and more is that the anti-poverty movement and the reproductive justice movement and civil rights movements are more and more recognizing that our struggle is the same. And one set of arguments that has some appeal and persuasive power are economic arguments, a lot of like what we're talking about today. You know, family planning, it just makes economic sense, not just for the woman and her family, but for our entire society. It saves money, saves government money, it makes people more productive workers and higher earners, it contributes to the economy. So I think while the Hyde Amendment isn't going anywhere now, the more we can educate our fellow citizens about the economic implications of everything we're talking about today, that someday it may happen.
That's if common sense prevails. And true to that point, we did some work in Atlanta and found that if you could magically subtract all the black women just from the 2 counties that make up Atlanta, the economy of the state collapses. So there are some folks who think perhaps a common sense action will take place and Hyde will be repealed because the greater inequalities in income and wealth get, the worse and more destabilizing they destabilize our local economies and national economy becomes. So hopefully, I wouldn't wager a prediction on that. But also around the issue of sort of the myths, you know, black women and Latinas have been viewed as hypersexual beings, or in the case of black women, the mammy figure. And you know, there's lots of research on why, but these images serve to perpetuate certain policies that are advanced by certain political leanings. And part of, you know, hopefully that will change as demographically the country shifts, but part of what contributes to this is how we talk about race, and we say things are due to race, these happen to black women, and we end up essentially blaming the victim. So we need to change our conversation, change the way we refer to data, how we talk about data and human beings to help prevent that from continuing.
You had asked about the role of physicians in advocacy. And I would say that it's really hard for it's difficult for physicians to be out there and advocating for themselves when they're so concerned about their safety and their family's safety. In fact, I'm here today because our physicians don't feel comfortable standing up and putting their name out there on a public forum like this. And you know, they went through 14 plus years of medical training to be doctors and to provide medical care to women. That being said, I have found that physicians who are providing family planning services, they are not a quiet group. And they do care immensely about this and about women having access to their expertise and to them. And so I think that we just need to be cognizant of the safety issue and respecting their training and finding a role for them.
Thank you so much for your answers, your advice, and your foresight. We thank you.